Hello, this is the presentation that I promised you, your YouTube video, etc., on rules of evidence. So this is for the trials unit for this week. So you're supposed to watch this on April 4th, 2018. And it should take, I think it'll probably go about a half an hour. And I will also post the PowerPoint itself so you can look at it at your leisure. So, what is evidence? Well, the rules of evidence are used to determine what the trier of fact, whether it's a judge or a jury, what the trier of fact is allowed to consider in rendering a verdict in a case, whether it is a civil case or a criminal case. Trial judges make those rulings. They apply the rules of evidence to make decisions about evidence that is offered by any of the parties, and to decide whether it will, as they say, come into evidence, whether it will be received into evidence. In other words, become a part of the record of the case and usable by the trier of fact to render a verdict. If evidence is not admitted, it may not be used in any way in rendering a verdict in a case. Understand that the rules of evidence apply to both criminal and civil cases. Just as trials are basically the same, they are run in essentially the same way. There are some differences, but almost entirely all the stages are the same in civil and criminal, and the rules of evidence are the same. Now, the first question we have to address about evidence is what kinds of evidence are admissible? And in a minute we'll talk about what kinds of evidence there are, but now we're going to look at the issue of what types of evidence are admissible. In order for evidence to be admissible, it has to be relevant, material, and competent. Now, what does that mean? Relevant means that the evidence has some tendency in reason, some reasonable tendency to make a fact in the case either more probable or less probable. So evidence is used to prove that facts are either true or false, right? To prove or disprove a fact. Evidence is used to prove or disprove a fact. Evidence is relevant if it actually has a tendency, a reasonable tendency, to make a fact more or less probable, more or less likely to be true, in other words. Now, but evidence could be relevant but not material. And materiality goes to what are the actual issues in a case. Because there may be items of evidence that prove facts, so it's relevant. The evidence is relevant in the sense that it proves a fact, but the fact may not matter given the posture of the case at a given time. And so it is not material if it is offered to prove a fact that is not at issue. If it is offered to prove a fact that really is at issue, in other words, an issue that is being disputed, a fact that is being disputed, that is material. If the parties agree on something, if they've stipulated, or if there's a matter that just is not at issue, they don't disagree about it, then evidence that might be relevant to prove that fact doesn't matter. So materiality means does it matter or not. Relevance means does it tend to prove anything or not. So those are the two ideas. It has to be relevant to prove a fact, and it has to be, then the fact that is offered to prove it has to be material or matter in that case. We don't waste time proving facts that aren't material. And third, it has to be competent, meaning it has to be essentially reliable. And this is a very old concept in the law. So, for example, a witness may not be, as they say, competent to testify, like a small child or a person who is severely mentally ill or is under the influence of some kind of a drug. I mean, if you went to take someone's testimony and they were in a hospital and they'd been drugged up and didn't know where they were, they're not competent to testify at that moment. A 3-year-old is not competent to testify. And so competency for a witness normally refers to the ability to take an oath and understand what the oath means, to understand that it's under penalty of perjury, personal knowledge of what they are testifying about, the ability to remember, and the ability to communicate. And then with respect to documents and other types of things, as you'll hear, we use the term authentication to make sure that these items, whatever they are, this is analogous to competence of a witness. We use terms to describe that this document has been authenticated, meaning it is the real document, or it is the real gun, or it is the real cash register, whatever it might be. Now, if evidence is relevant, if it is material, and if it is competent or authenticated, it is almost always admissible. Now, the only time normally that it would not be admissible, assuming it is relevant, material, and competent, would be if it is privileged, or it is subject to the exclusionary rule, which only applies in criminal cases. That means it was seized in violation of the defendant's constitutional rights, so it is excluded for policy reasons to protect the Constitution. Well, that's a way that relevant, material, and competent evidence may not be allowed in the case. It's excluded under the exclusionary rule, or it might be privileged. And a privilege involves special types of communications and other material that are, for other reasons, that are not allowed in evidence. And we'll talk about that in a minute. I'm going to get to that. I'll have a slide on privilege. Now, when an attorney wants to introduce an item of evidence, they have to lay out what's called a foundation for introducing the evidence. That means enough preliminary evidence that the item or testimony is authentic and relevant, that it is the thing it is supposed to be. The attorney says it is something, but the attorney isn't testifying. The attorney's words are not testimony. They are not evidence. So you have to have a witness who's giving sworn testimony. That is evidence. And a witness has to authenticate the evidence as being what you say, what the attorney claims it is. So normally the witness has to have personal knowledge about the case or the facts or something, and they have to be competent to testify. I'll give you an example in a minute, but the foundation for physical evidence is that it is the thing it is supposed to be. So the witness says, for example, yes, let me look at that gun. Oh yeah, that's the pistol that was stolen from my bedroom last year. That used to be my gun. Yep, that's it. Or in the case of a document, a business record or a birth certificate or something, somebody has to be able to testify. Usually it's what's a person who's called the custodian of records for a business or a government agency, but it wouldn't necessarily have to be. It might be your own family Bible or something. Yes, that is my family Bible, and it shows when everybody was born. So somebody who's a witness, who's a sworn witness, not the lawyer, has to authenticate documents and items in order for them to be admitted into evidence, just like a witness has to be competent. Someone has to explain this is the real thing. Now, when something is offered in evidence, maybe a question is asked of a witness, or the attorney moves to introduce an item, the other attorney can object. And when they object, they have to say why they are objecting. They have to state the grounds for the objection. So that usually involves something about the evidence code or the rules of evidence. It has to, they might say, for example, wait, that document has not been authenticated as the correct document, as the original document. Or, wait, you've moved to introduce that gun into evidence, but no witness has testified that it is the gun we've been talking about in this case. How do we know it's the real gun? Or you offer a vial of the defendant's blood in a drunk driving case, and they say, wait, nobody ever authenticated the process by which that blood was taken. How do we know that's really his blood? So attorneys have to cover all this before they introduce items into evidence. And when they ask questions, questions are routinely objected to on the grounds that the question or the form of the question is wrong, that it's an improper question, and sometimes they'll move to strike the answer because the answer, for example, is not responsive to the question. A very common motion to strike is attorney asks a question and the witness does not respond to the question but says something else that they want to say. So you ask a witness something like, where were you on the night of the 23rd? And the witness says, that guy sitting over there is the guy who attacked me. And the attorney would say, I move to strike the answer as unresponsive or non-responsive, meaning that's not the question I asked. The witnesses can't just stand up there and volunteer things like they do on television. They have to respond to questions. And anything they say that is not responsive to a question can be struck from the record as non-responsive. Now, let's talk about what types of evidence there are. There are basically 4 types of evidence. Type 1, real evidence. That's what we call it, real evidence. It means objects, guns, drugs, clothing. It is things. A thing with characteristics that are both relevant to prove a fact and material in that they are relevant to a fact that matters in the case. Usually, real evidence is something that was actually involved in the incident that is at issue, whether it's civil or criminal. So it would be, in a criminal case, the murder weapon, for example. Or if you have a civil case. For example, let's say you have a plane crash and there's a lawsuit over the reason a plane crashed, and you bring into the court the actual broken part that caused the crash, or maybe the altimeter was reading wrong and it gave the wrong altitude to the pilot, and you're suing the manufacturer of the plane for having a faulty altimeter in it. It says how high the plane is. So you say, here is the altimeter. Somebody has to testify to authenticate it, that this was the altimeter that was in the plane. And often that includes evidence of what's called the chain of custody. Like, where was it? Who took it out of the plane? Where did it go then? Where did it go after that, and after that, and after that? And how did it get here? That's called the chain of custody. And that is all done by witnesses. Another type of evidence, second type, is testimonial evidence. That is statements from witnesses about things that they actually perceived. Now, so there's two types of witnesses, testimonial witnesses. One, what we call a lay witness, or a percipient witness. In other words, as in perceived. They testify to what they perceived. And they can give some opinions, but they're like ordinary opinions that we call rationally based on their perception, such as, in my opinion, the weather was hot that day. Well, you're not a meteorologist, but you know how you felt. The weather, it felt hot, right? These are ordinary opinions. Or, in my opinion, person A was taller than person B. These are things you could see. So they testify to what they perceived and ordinary opinions. As you may note, one of the things they can't do, and this is called the rule against hearsay that I'm going to talk about in a minute, they can't just spout off about what other people said. They can talk about what they can talk about what they saw, and sometimes what they heard might be relevant, but they can't get up there and like testify for people who aren't there. They have to talk about what they perceived, what they heard, and so forth. The other type of testimonial evidence is from what are called expert witnesses. These are people who have special knowledge or special expertise that entitles them to render professional expert opinions, which ordinary witnesses cannot do. Expert witnesses normally are not percipient. They didn't see any of the events in question, or very few of them, if any. And so they give an opinion, and they write reports, and they have their depositions taken, and they say things like, I believe that the physician, who is the defendant in this case, say it's a medical malpractice case, performed the surgery in a manner that is below the standard of care or standard of practice in the surgical profession. I believe basically that the defendant was negligent. That's essentially what they say. Now, or some other opinion, but opinions are the province of expert witnesses for the most part, expert opinions. And they have to have qualifications in order to render opinions. They have to qualify as experts. They have to talk about their expertise, their training, their experience, etc., and satisfy the judge that they really are experts. A third type of evidence is what we call documentary evidence. That means what it sounds like, documents. But documents can be any kind of a written or video or audio item of evidence, not just paper. Documentary evidence would include photographs, videotapes, audio recordings, etc. And there are special problems, and some of them I'm going to talk about later on briefly, but the best evidence rule, the parole evidence rule, best evidence means you have to use the original if you can possibly get it. You can't just introduce copies of documents if the original is available. Parole evidence rule has to do with contract cases, and I'm going to explain that in a bit. Again, documents have to be authenticated, and they are also subject to the hearsay rule. And you'll understand why when I tell you what hearsay is. But documents are almost always hearsay, and they have to satisfy exceptions to the hearsay rule. Fourth and last type of evidence is what is called demonstrative evidence. This is evidence that was not. It is objects like real evidence, but they're not the ones that were actually used or that were actually in the incident that led to the case. So, if the altimeter for the plane was destroyed in the crash, you bring in another altimeter, and that's called demonstrative evidence. You say, this is exactly like the one that was destroyed. Now you can see what they look like, but everyone understands it's not the one that was at issue in the case. Or you can't find the gun that was used to fire the fatal shot. Nobody ever found it. It's gone. But you have verified what type of gun it was. So say it was a 9 millimeter Smith and Wesson, etc. And you know that because of the scientific evidence, and they say where the lands and grooves and the bullet markings, etc. So okay, whatever reason, you understand that it was that type of gun that was used, but the gun's gone. So what do? You bring in another one so the jury and the judge can see what it looks like, how heavy it is, what it looks like. But they all understand this is demonstrative evidence. This is not the one that was at issue. Maps, diagrams, etc. These things are demonstrative evidence. When you draw a map, when you draw a diagram, often we use videos now, videos to recreate the incident, like a car accident, and they use CGI to do that, and that's demonstrative evidence too. It's used a lot in personal injury cases to recreate accidents and that sort of thing. Now, another thing, and this is really important for you to understand, there are two types of evidence, again, if you divide it up this way: direct evidence versus circumstantial evidence. And I'm emphasizing this because, jumping to the bottom, contrary to what most people believe, there's nothing wrong with circumstantial evidence. People are always saying, well, all they have is circumstantial evidence. Yeah, well, under the law, circumstantial evidence is entitled to exactly the same weight as direct evidence. Exactly the same weight. It is not less important than direct evidence. In fact, in many cases, circumstantial evidence is much more persuasive than direct evidence. So when you hear people say, well, all they have is circumstantial evidence, don't be fooled. That's just as good as direct evidence. What's the difference? Direct evidence refers to evidence that directly tends to prove a fact. A witness says on the witness stand, and remember, this witness talking, that's evidence. The words of the witness from the witness stand are evidence. They are direct evidence because the witness is going to say, I saw a person walk across my backyard. Now, that evidence tends to, those words, I saw a person walk across my backyard, tends directly to prove a fact. What fact? That a person walked across the backyard. That's the fact. And what is the direct evidence of it? The witness says, I saw someone walk across my backyard. There's no in-between inference. We go straight from the witness. If you believe the witness, it tends to prove the fact. Circumstantial evidence is one step removed. It tends to prove one fact from which a second fact can be inferred. So here's an example. For example, the witness says, instead of saying, I saw a person walk across my backyard, the witness says, I woke up in the morning, I looked out the window. There was snow on the ground that fell during the night because there was no snow when I went to bed. When I got up in the morning, there was snow on the ground. And I saw there were footprints in the snow. That's what the witness says. I saw footprints in the newly fallen snow. Now, what does that mean? Well, it is circumstantial evidence of something. Of what? Okay, fact number one. This is what the witness testifies to. I saw footprints in the fallen snow. But that tends to prove fact number two. A person walked across the backyard. So you see, both these items of evidence are the direct and the circumstantial. They both tend to prove the same fact. And they're both probably equally reliable. I mean, it's possible the witness who says, I saw a person walk across my backyard could be lying. Maybe they don't have good vision. Maybe they forgot the day. I don't know. It's the same thing here. The circumstantial evidence says there was snow on the ground and there were footprints in the snow. Well, how could footprints get in the snow unless somebody walked across the backyard? That's why they're given exactly the same weight. And in fact, sometimes circumstantial evidence is overwhelmingly persuasive. And that is particularly when there are jury instructions that tell the jury how to use circumstantial evidence. And typically, they'll get an instruction that says, take all of the circumstantial evidence as a whole. If it is susceptible of only one reasonable interpretation, taken as a whole, then that you should find that it's true. Now, what that means is that, sometimes attorneys try to explain away a lot of circumstantial evidence by using a different explanation for each piece of evidence. And the problem, someone offering a circumstantial evidence case, what they will try to do is argue that, look, there's only one thing happened here. The O.J. Simpson case was a lot of circumstantial evidence, but all the circumstantial evidence pointed in the same direction. And in other words, O.J. Simpson's blood was found at the scene of the murders. The victim's blood was found in O.J. Simpson's car, etc. And there are many other facts. Now, the normal way to argue this is to say, look at all that evidence. There's only one explanation, one sequence of facts that explains all of it. Now, the defense attorneys might say, well, okay, the reason his blood was at the scene is because 2 days ago he was there and he bled there. And why was the victim's blood in his car? Oh, we don't know. Maybe, somebody else did the murder and got into his car. These are two different explanations. And so often circumstantial evidence can be very persuasive because the side that's offering the circumstantial evidence case says there's only one way this could all be explained. There's only one version of events that covers all the circumstances. Now we come to privilege. I mentioned this earlier. Some facts are privileged. Now what that means is that somebody holds a privilege. Somebody has the right to refuse to disclose the information in the court. And the holder of the privilege can invoke the privilege and refuse to disclose the information. One of the most bulletproof privileges is what's called the attorney work product doctrine. The mental impressions, the notes taken, etc., by an attorney are absolutely, totally privileged. You cannot make an attorney divulge their notes, their drafts of the documents that they prepared. This is all protected. The attorney work product doctrine, it's all privileged. Second attorney privilege is what's called the attorney-client privilege, and that involves communications between the attorney and the client. Those are absolutely privileged, almost never revealed. Third, another example is the marital communication privilege. There are two privileges involving marriage. One is the marital communication privilege, which means communication between the spouses. That's privileged, and both spouses hold it. So you can't make, they both have to consent to reveal their confidential privilege communications between each other. Now there are exceptions to this, like in a divorce case, that goes right out the window. Child custody, that goes right out the window. But in many other cases, their communications are privileged. And then there's the testimonial privilege. That is a privilege to not have your spouse testify against you or to not be forced to testify against your spouse. So one is communications, the other is testimony. Other privileges, there are many others. In some states, reporters are protected by something called a shield law, which means they don't have to reveal their sources. There is no shield law in the federal system, however. There is no federal shield law. And that means that reporters who refuse to respond to subpoenas in the Mueller investigation or something, if that should happen, have no protection. They'll go right into jail if they don't reveal their sources. They'll be held for contempt. But in most states, there's a shield law, and they can refuse to reveal their sources. Another one is clergy penitent privilege, where you go to a priest or somebody else and you tell them your sins, your confidential communications with your clergy person. Those are usually privileged. Same thing for talking to a psychotherapist, and there are other privileges as well, but you get the idea. Whoever holds the privilege can refuse to disclose the information. Some other special rules, something called the best evidence rule. This is for all types of cases. You can't introduce a copy of a document into evidence unless the original document cannot be obtained and introduced. In other words, as long as it is possible to get the original, you have to get the original. Now, the exception to that would be stipulations. Sometimes the attorneys will stipulate, both sides will say, no, we know that this isn't the original, but we know it's an accurate copy. But if either party wants to insist on it, they can force you to produce the original document. So if you're an attorney, sometimes you have to be aware of that in advance. So you have to find out where the original is. This can be, sometimes it's unobtainable, like a birth certificate. The original birth record. Remember this thing with Barack Obama? The original record of our births is not actually available. It is kept in some government office and it is never released. What you get instead is a birth certificate, which is something that is issued any day you want it. You ask, it's dated today. If you ask for one today, it'll be dated today. But it'll say, I'm the clerk in charge of these records, and I checked the original birth record that is on file that you're not ever going to see. And it says that this person was born on such and such a date. So in the case of Barack Obama, they came up with birth certificates and put them online saying, we have the Department of Health in Hawaii says he was born on, whatever it was, August 8th, 1961, or whatever the date was. And that's not the original birth record. And so all the right-wingers were demanding to see his, quote, long-form birth certificate. What they meant by that was the original birth record. Well, he doesn't have that. You don't have it. I don't have it. Nobody gets it. My original birth record is in Piscataquis County, Maine, in some office someplace, and I'll never see it, but I have a birth certificate. Same thing for you. If you were born in Chicago, it's on record. Your original birth record is unobtainable. So, but you can get a birth certificate, see, a certified copy of a birth certificate. So the best evidence rule says you got to get the original if you can. If you can't, then you can use a copy, and sometimes it's a certified copy, meaning the custodian of records puts a stamp on it and says, this is a valid one. Then there's this weird thing called the parole evidence rule. Parole is a French word, just means basically word, but a speech. It is a reference to contract cases. This is only used in cases involving written contracts. And it goes like this. If you have a case involving a written contract, and the judge finds that that was intended to be the party's complete and final expression of the agreement. If that's what you have we were suing for breach of contract, and you say, Your Honor, here's the original contract signed by the parties. Satisfies the best evidence rules. Get the original signatures. The judge says, okay, that's the complete and final expression of the agreement. And then the other side says, oh, wait a minute. We had another conversation. We had a conversation before we signed the contract. And we agreed that there were some other terms. The judge is going to say, I don't care, it doesn't matter. That's parole evidence. If you have a written agreement that is the final expression of the deal, you cannot introduce any evidence of other prior or contemporaneous negotiations or agreements that modify or contradict, I said contract, I should say contradict the contract. You can't. And that's because everything before that is deemed irrelevant. All the negotiations that you did before you signed the contract, that was your final agreement, all those negotiations and agreements and everything else that came before the contract, that's all irrelevant. That all went into the negotiation process. Once you signed a contract, that's the deal. And that's called the parole evidence rule. Now, here we're going to spend a little time on this. This is called hearsay testimony. It happens all the time. Here's what hearsay is. Hearsay is testimony, first of all. It's testimonial evidence. Testimony that is offered in court by a witness. So there's a witness up on the witness stand. And the witness says something. And the witness's testimony includes something that somebody else said. And that statement is an out-of-court statement, meaning the witness is saying, I'm here today telling you something that somebody else said yesterday or the day before or a year ago. Now, the witness is the person testifying. The person who made the out-of-court statement is called the hearsay declarant. Now, when this happens, the question is whether the witness's statement, when he says, Joe Blow said X. So Joe Blow is the hearsay declarant. The witness is saying, Joe Blow said X, right? That X is an out-of-court statement by a hearsay declarant named Joe Blow, right? And if that testimony, Joe Blow said X, is offered to prove the truth of whatever Joe Blow said, it's hearsay. So hearsay testimony is an out-of-court statement offered to prove the truth of the matter that is asserted in the statement. For example, the witness in court says, I talked with Twizzle. Bing, right there. You're as a lawyer, you instantly, when he says, I talked with Twizzle, your hearsay lights should start flashing. And he told me what? Now you know this is going to be an out-of-court statement. I talked with Twizzle and he told me. Out-of-court statement. He told me he saw the defendant shoot the victim. Why is that being introduced? Is it being offered to prove that the defendant shot the victim? If it is, it's hearsay. Now, the problem here is the witness is quoting the hearsay declarant. The witness can be cross-examined. You can say, did you hear that? Do you have good hearing? But the hearsay declarant is the one who says, I saw the defendant shoot the victim. You have no way of cross-examining Mr. Twizzle. Mr. Twizzle isn't there. So how does anybody know whether he saw this or not. There's no way to test the reliability of Twizzle's out-of-court statement. We can question the witness sitting on the stand. Did you hear him? Could you see him? Do you know him? Etc. But you can't cross-examine Twizzle. So it's as if Twizzle was on the witness stand saying, I saw the defendant shoot the victim, but you can't cross-examine him about that. So that evidence is hearsay testimony, and unless it qualifies under an exception, it's going to be excluded. That's what hearsay is. An out-of-court statement that, by a person called the hearsay declarant that is offered to prove the truth of whatever the hearsay declarant said. And the problem is you can't cross-examine the hearsay declarant because they're not there. Now, there are exceptions to the hearsay rule, and then there are what are called exclusions from the hearsay rule. Exceptions are when it is hearsay, as absolutely hearsay, but there are particular reasons why it's reliable anyway, even though it is hearsay. And then there's other situations where it is not legally defined as hearsay because it is offered for some reason other than to prove the truth of what the hearsay declarant said. There's another reason why you're offering it, and you'll see this. I'll go over this in a minute. Here are the major exceptions to the hearsay rule. This is from the Federal Rules of Evidence. One is called a statement against interest. What if the witness says, well, you know, Twizzle said, and then he goes on to say, Twizzle said, I committed that murder. Well, that is usually deemed reliable. That's hearsay, is absolutely hearsay. It is offered to prove the truth. If it is offered to prove the truth that he committed the homicide, yeah, it's hearsay. But the logic is nobody would say that unless it was true because it's against his own interest. So it's probably reliable. Another situation is what are called present sense impressions and excited utterances, where someone said, the witness on the stand says that the hearsay declarant said, ouch, I just burned my finger. Is that offered to prove that the guy burned his finger? Yep, yeah, it is. It's hearsay. But it's an exception because the idea is you're swept up in the moment. It was your statement was a reaction. You didn't have time to think about it. It's probably reliable because, ow, that hurts. I burned my finger. See, that was like a reaction, a present sense impression. And so it's deemed reliable. Another one, existing mental, emotional, or physical condition. You know, the same type of thing. Ow, you know, I stubbed my toe. I feel depressed. Well, that's if that's what the hearsay declarant said. Those are deemed reliable because people are, again, swept up in the moment. Medical diagnoses or treatment, the notion is people don't lie about that. If they tell you, the witness says, he told me he had cancer, that's hearsay if it's offered to prove that he had cancer. But the logic is he wouldn't lie about something like that. And now we get several exceptions for records. Recorded recollections, that's where someone wrote something down on purpose. Records of regularly conducted activity. These are records just routinely made in the course of business by people who have no incentive to lie. Public records and reports. Vital statistics, public, birth and death records, etc. Records of religious organizations, marriage certificates, etc. Property documents, ancient documents, market reports, learned treatises. Basically, these are all types of records. And if you can just authenticate the record to say that it really is a public record, it really is a vital statistic, it really is a business record of a business, and they normally keep these records of the comings and goings and the checking of the various valves in a factory or the people who entered and left a building. This is just the normal, these records that are made in the normal course of business or government, those are hearsay, they're absolutely hearsay, but they're almost always admitted as long as you can prove they're authentic. Because the logic is, well, people don't lie about stuff like that. Public, business, records, etc. are usually reliable. Then sometimes character witness, character evidence. Witnesses are often allowed to testify, they say, when they're offering what's called character evidence. And this comes up in certain special situations in trials. Defendants sometimes offer evidence of their good character in a criminal case. Their character might be at issue in a civil case too. And when they do that, they ask witnesses, do you know this person's reputation in the community? And the witness is going to testify that, I've known the defendant and I know his friends and neighbors and family, and he is regarded in the community as a wonderful, honest person. That's character evidence. That's based on hearsay. Because if you say, how do you know that? You'd say, well, Everyone told me that he's a great guy. That's hearsay, isn't it? Because the witness is talking about hearsay declarants who told him things out in the world. That's usually allowed in evidence, and there are special rules for it. On the theory, again, that you're just talking about it's probably true. These are probably, you can cross-examine the person who gives the testimony, the character witness, him or herself, but but we don't know, we don't have a way of getting at everyone in the community, so they allow it in. And then conviction records, the boundaries of property. Again, these are in the category of business and public records. So you get the logic. Records that were just put together by ordinary people in the course of business, no reason to believe that they're falsified. Now, they could be. Someone might offer evidence that they are, but I'm saying they are admitted even though they're hearsay. Then there's some things that are not hearsay, that sound exactly like they are. And that is, remember the statement I said earlier where so-and-so says, the witness says, yeah, Twizzle told me that he saw the defendant commit the crime. Now, if the hearsay statement is offered for some other purpose than to prove the truth of what was stated, it will come in anyway, because the jury will be told, this doesn't count on the issue of whether the defendant committed the murder or not. It counts for some other purpose. For example, it counts to prove where he was at a certain time. The witness is saying, yeah, I was in a bar and I saw him there, and are you sure it was him? Yeah, did you have a conversation with him? Yeah, he's, etc. So the evidence is offered for some other purpose. Now, the most common other purpose is to impeach the witness. Impeaching the witness means undermining the witness's credibility with a prior statement they made that is inconsistent with what they said in court. So, for example, a witness gets on the stand and says, yeah, I was at the scene of the accident, the car accident, and I saw the car that rear-ended the plaintiff's car, and what color was it? It was black. So up comes, on cross-examination, up comes the other attorney, and he goes up with a piece of paper. And he says, do you remember giving a statement to the police at the time of the accident? And it says, yes. I did talk to the police. And he said, did you write down a statement and give it to them? Oh, yeah, I did. Look at this piece of paper. Is this the statement that you gave them? Yes, it is. Okay, now, that is an out-of-court statement. You hand it to the witness and you say, read what it says here. Oh, I saw the car and it was blue. Oops. What do we have there? That is an out-of-court statement. It's hearsay, except that it's excluded from the hearsay rule. Why? Because the attorney's saying, Your Honor, I'm not offering this to prove that the car was blue. I'm offering to prove that this witness can't remember what color the car was. And this witness has a faulty memory. I want to undermine everything they said, all their testimony. I don't think they remember a thing. And I'm going to impeach them by showing that they got this statement wrong, I don't care whether the car was black or blue. Maybe it was pink. It doesn't make any difference. So I'm not offering the statement, the car was blue, because I want to prove it was blue. That's proving the truth of the statement. I'm offering it to prove this witness has a faulty memory because he said two different things. He said one thing at the scene, he said another thing in court. You can't believe this witness. That's called impeaching a witness. And other things like the statements by opposing parties are admitted. In other words, if I'm the plaintiff, I can offer the defendant's statements into evidence, even though they're hearsay. Yeah, he said at the scene, blah, blah, blah. It's just allowed. And the defense can say, well, I talked to the plaintiff at the scene and he said, why? Well, why? Because the parties are right there in court. And their statements, their out-of-court statements are offered for the truth of those statements. It doesn't matter, because if they don't like it, they can get up on the stand and deny it. Because they are not truly absent from court, like ordinarily the hearsay declarant is nowhere to be found. Well, here you have the parties right there. If you don't think it's true, get up and say it's wrong. Now, I'll just wrap up here. Last point. I mentioned to you that the rules of evidence of the state of Illinois were codified finally a few years ago. And this is a link, this last slide is a link to those materials at the Chicago Bar Association. It is a color-coded, very neat guide to the rules of evidence. So if you're interested in it for any reason, I'm not going to test you on it, but if there's something you want to read about what I've said that you don't understand, almost all of this is actually in, or I guess all of it, is in the rules of evidence. of the state of Illinois, which kind of track the federal rules of evidence. So that's the end of this presentation, and I hope you've enjoyed it, and I will see you Friday.